A few words about the civil liability arising from AI and big data. The concept of civil liability in relation to AI leaves a lot of open-ended questions. And it is our expectation that exactly these questions will drive the creation of new legislation concerning the civil liability of AI-related damages. The first problem concerns the AI creator, because no matter how expensive the AI is, it will be used to manage more expensive processes. So an AI failure might easily cost much more than the AI creator has received in remuneration for his work. Under Bulgarian law, it is possible to limit liability for damages due to common negligence, and compensations are always for actual damages suffered or proven missed gains, but only the ones which could have been predicted at the conclusion of the contract. So the AI manufacturer has the tools to negotiate the right price for the risks being taken. And additionally, those are risks that can be insured. Though the insurance market in Bulgaria has yet to start thinking about insuring the civil liability arising from the use of any type of software. The relations between manufacturer and user are quite malleable in the end. Even considering the pretty rigid Bulgarian contract law, the manufacturer can stipulate what guarantees are provided, that the AI will provide certain results and be held liable for failing to achieve them. The problem with liability towards third persons, especially in cases of torts, is more complicated. As the first question that needs an answer at fundamental legal level, we can ask whether AI activity is currently regulated under law. Because the law regulates the behavior of natural persons, even when an obligation concerns a company or even a state, it is always to be performed by a specific human being. Without resolving this matter, all actions of an AI, regardless of their effect, will remain beyond the scope of the law. Currently, an attempt to attribute AI actions to the author might be made, but given the very nature of AI, this will not be possible, because liability is tied to the concept that actions can be controlled, and only guilty actions lead to an obligation to compensate the damages caused. Only an exclusion liability can arise without an action or without guilt, but only on grounds of an explicit provision of the law. The second question is how future law on AI liability should be formulated to adequately provide for all stakeholders. There are some ideas on this topic in European Parliament resolution from the 20 October 2020, with recommendations to the Commission on a civil liability regime for AI, which states that the existing framework in the field of civil liability will suffice without granting a legal personality to AI systems. The liability for any harm or damages arising from the use of AI will fall upon the operators, in a rough analogy to the regime for liability of producers of defectwares and the regime for civil liability of car owners. This liability will be shared between the front-end and back-end operators, the former including the persons working with the AI, and the latter any person who on a continuous basis defines the features of the AI or provides data and essential back-end support. Operations will be regulated differently on the basis of an assessment of what risks are inherent to a certain activity or field, whereas high-risk AI systems should be exhaustively listed in the regulation to be adopted. The resolution also covers secondary questions related to liability, such as recording data concerning harm damage caused to third parties, fast-track approval of AI systems, and assessing the potential risks associated with them, setting standards for amount and extent of compensations for violations of fundamental rights, introducing a mandatory liability insurance regime for operators of AI systems. Currently, there are no applicable standards in Bulgaria for the use of AI and big data, including when considering specific regulated activities, such as practicing medicine or law, and respectively, there are no specific rules on malpractice. Given the concept of personal liability for decisions, it is not to be expected that this specific approach will change in the near future. For now, AI and big data are rather additional instruments which do not change the requirements for care and performing obligations, both for specialized activities and for everyday company management. A short review of the possibility of criminal issues arising with regard of AI and big data. The concept of crime in Bulgarian law is closely related to the delict as grounds for the arising of civil liability. As a result, a lot of the problems mentioned in cases of civil liability are relevant to criminal issues as well. However, the concept that only the behavior of a human being can be regulated via criminal law is much more deeply rooted. In the national law of European countries, the concept that companies can commit a crime seems almost impossible, including the understanding of how crime can be prevented and respectively sanctioned. It should be noted, of course, that there are some exclusions in that regard, especially when it comes to money laundering and terrorism. The problem is that the lack of regulation does not mean a lack of opportunities for criminal issues to arise. An AI can conduct illegal acts both by design and by accident. And if adequate measures are not taken, then the cases where the illegal acts are a result of design will increase both as a percentage and as a total number. This is the reason that criminal law can endure a vacuum in regulation for a short period of time only, even if AI civil liability is more justifiable as a legal construct. For now, the most possible solution seems to be to impose obligations on AI developers to make AI adhere to the law. The questions asked when criminal issues are involved will be similar to the ones asked when talking about civil liability, but with a greater emphasis on establishing the chain of cause and effect. However, time would play a much more significant role as a factor, because civil liability can boil down to the obligation to repair any damage done, but criminal liability is always for committing an act that has been strictly prohibited as a crime by the law at the time in question. A natural question arises. What if an AI is programmed to act in accordance with the law at the moment it has been developed, but commits a crime either because it has evolved or because the law has changed at a later point? Any attempt to answer this question can currently only be speculation, but for now, asking the right questions will be more than enough, because any criminal issue will quickly reflect on the relations between the AI manufacturer and the user. Matters related to criminal activity must be discussed between the parties in time to protect their interests and give them a chance to prepare for the possible risks. In conclusion, a few words about the possibility of discrimination and bias when talking about AI and big data. In terms of protection against discrimination, some of the concerns for anti-competition measures shall apply. Bulgarian law shall currently deem any action by an AI to be taken on behalf of a person, and that person shall be held liable if the action has resulted in discrimination. So companies using AI have the responsibility to check any decisions to make sure they do not involve a judgment on the basis of discrimination. It should be noted that there are two very important rights of data subjects when it comes to protection against discrimination and bias decisions, granted under GDPR: to be informed when the data is being processed automatically and to object against such processing. GDPR states some cases where such an objection is impossible, but then the data subject has the right to require human intervention to express a point of view on the matter and contest the decision taken automatically. The only exclusion where these rights do not apply is when EU or national law authorizes the use of automated decisions and requires suitable measures to guarantee the rights of the data subject. In accordance with GDPR, the Bulgarian Act on Personal Data Protection requires that automated data processing, including AI, should have always be conducted only after an impact assessment. As a result, starting such an operation shall require a very careful analysis of the safeguards guaranteeing data security on one hand and the rights of the data subjects on the other.